Hello, this is John Milburn for Central Queensland University. This is Prop 13001, Property Development, Week 7. This week we're dealing with construction. So when a developer has purchased development land, obtained approvals, the next critical step is construction. This is, of course, a huge step. And no doubt developers would plan well in advance in terms of what would happen in the construction phase. But there are elements of construction that occur at the land contract stage, and the cost of construction is a vital component, of course, of any cash flow projection for the entire development project. So what are the ways in which a property developer might procure a construction contract? Well, the first thing is to identify that there might be more than one contract, and there may be a series of concertina contracts that the property developer considers. Although typically, where possible, the property developer would seek to engage a head contractor who then goes about the task of organising the subcontractors. So usually the contract would be on a design, bid, build process, which is the traditional approach, but increasingly commonly we have a design build approach to the construction phase. Put simply, property developers must decide whether to engage an architect and a full team of advisors to create and present a proposed development to contractors, where they then bid upon that construction project. That is the traditional approach. Or alternatively, to shortcut many of those circuits and also costs by simply approaching a contractor to enter into a contract, and the professional team have already provided advice. Have a look at 7.3.5 of your text, which provides for some detail about the different approaches that the property developer might adopt at that stage. And your text, of course, is Property Development by Richard Reed and Sally Sims, which is that text. Okay, so property developers, of course, usually work as part of a team or with a team of professionals. The architect would usually be the person primarily responsible for the preparation of the plans, obtaining planning permissions, statutory approvals, and directly involved in engaging the contractor and dealing directly with the contractor once the construction has commenced. However, the team might include town planners, quantity surveyors, engineers, project managers, and of course lawyers are never far from the scene. As a prudent property developer, one would expect you to develop your own checklists to ensure that you are engaging professionals and contractors and that you've considered all relevant factors as part of the phase and you've made appropriate decisions in relation to the circumstances that you find yourself in at that stage. So you'll need to understand the basis upon which the contractors and the professional team charge their fees. Many work on a professional fee which is based on percentage. Lawyers usually work on an hourly rate. One of the first things that you should consider is the material that's on website. I would urge you to look at the Queensland Building and Construction Commission, the QBCC, for relevant information in Queensland. Also, consider the Department of Housing and Public Works and the Queensland Development Code, which provides for specific building standards into a single document, and that website link is on in your study notes. But that's the Department of Housing and Public Works, referred to the Queensland Development Code. Okay, let's now talk about the development approach and the construction approach. The traditional approach, design it, then bid and build. So this means that the architect will generally lead the process at the instruction of and the engagement of the property developer. When entering into the methodology, property developers should consider having some structure to provide for a performance bond. That is effectively a contractual guarantee, and usually that performance bond will be provided by an unconditional bank guarantee. It can be a cash deposit or retention of funds, but usually an unconditional bank guarantee. Now, when we say unconditional, we mean exactly that. It's unconditional. So the developer can call upon that bond at any stage without even giving a reason to the contractor. However, a prudent contractor will be aware that it is appropriate in some circumstances to engage lawyers to seek an injunction to restrain the property developer from exercising that entitlement if they believe that there is no real basis for the property developer to do so. Now, property developers need to, of course, consider their cash flow in order to pay the contractor at the time when the contractor calls for payment. So that means when preparing the contract in a design, bid and build process, the property developer must be very careful to ensure that they can pay the contractor when required. Now that might be on a reaching milestone basis, or it might be on a cost plus basis, or it might be on a monthly payment basis where work has been verified and certified as being completed. Now, the alternate approach, design build, lends itself a little more readily to a situation where the property developer can not only reduce time and cost associated with the building process, but also have greater flexibility in control in terms of when the payments might be made. By engaging a builder directly, the builder, the contractor, can be freed of the cost associated with bidding for a process, can work within plans that they're comfortable with, can use their established team, can therefore save considerable time and cost, and are far more likely to be flexible in terms of the costs associated with payment. Of course, the downside from the property developer's perspective is that it is much more a take it or leave it type situation, and the property developer may have the residual uncertainty as to whether in fact they got the best deal that they might have done by having a non-competitive situation by going with the design and build process rather than the bidding process that would otherwise form part of the construction phase. Now, there is another third, if you like, method, and that is management contracting. This is where the developer will engage a manager, effectively providing another layer into the construction process, and the management contracting allows for the manager to enter into specialist contract packages with a contractor or a multitude of contractors. But of course, the obvious disadvantage to the property developer is the additional fee that needs to be paid to the management contractor. Now, project management differs from management contracting in that project managers do not have the specific powers to issue remedies on behalf of a developer. Their role is simply to coordinate and deal with the overall management of the project, but they're not involved in carrying out the project. So, in short, a project manager is like, for want of a better term, a sergeant at arms for the property developer and is directly responsible for working with the property developer's consultants to produce the building on time and within budget, as per the commentary in Reed and Sims at 7.6.7. Now, in Queensland, contracts for construction are regulated, unsurprisingly, by legislation. Refer to the Building Act 1975, and that is very wide-reaching in its scope. It deals not with just traditional building work, as you might think of it, but also deals with certification, pool safety, and other issues. Have a look at chapters 2 to deal with what is an accessible development or accepted development under the Planning Act 2016, and have a look at chapter 3 that imposes requirements in addition to those under the Planning Act for making a building development application. See also the Building Regulation 2006. Have a look at the Queensland Development Code that I've already mentioned, which is the standard framework, and it extends upon the scope of the Building Code of Australia. And then consider alternate ways of dealing with issues associated with construction, and in particular ADR. So at the outset, a prudent property developer would consider issues of dispute resolution before engaging a contractor or entering into any contract. One way is to consider a formal process called partnering. It's essentially where key project participants, if you like, stakeholders, together work in a fashion that is partnering. It's a mutual commitment by the parties to facilitate improved contract performance, and it relies on each stakeholder to understand the communication styles, goals, and organisational interests of other members within the group. To form an ADR-orientated partnership, the partners form a relationship based on teamwork, cooperation, and shared vision. The whole idea of partnering is to improve communication, to anticipate problems before the event, and to deal with those problems in a controlled, regulated, respectful manner. It's all about developing systems to ensure that there's coordination of an understanding about the best way to deal with the partnership objectives overall. And when I say partnership, I don't really mean partnership in a legal sense. Partnering does not mean being legal partners. It means partnering in a more general sense, and it all revolves around dispute resolution through prevention as the key, rather than dealing with problems after they arise. Another concept is dispute resolution boards, which is a panel of typically 3 experienced, respected, and impartial reviewers. Their job is to deal with issues that might be arising on site. This is really for larger projects, and the board usually is selected by the contractor or through the contractor and the property developer. So the idea of the dispute resolution board is to have various hearings where each party to a potential dispute explains their position. The recommendation of the dispute resolution board is then made, and it's non-binding, but it is a way of trying to quickly evaluate problems by an impartial expert board that effectively take the place of lawyers and very expensive and very time-consuming litigation. So Dispute Resolution Board provides recommendations for resolution of disputes. It is non-binding, but it's something that should be considered from the outset rather than wait for the problems to arise. So it's a good way, together with partnering, it's a good way of dealing with issues before they arise. Now, the other things that the developer should consider when engaging a contractor are how to deal with delays, how to deal with collateral warranties, and ultimately to avoid liability where possible. So in that regard, in Queensland, property developers should consider their duty of care and consider the Civil Liability Act 2003. That Act provides a legislative framework for providing a general standard of care enforceable by those affected because of a failure of a party to abide by the appropriate standards of care. Now, these things directly relate to property developers. Property developers should be aware of Section 7 of the Civil Liability Act 2003 because it allows for contracting out of the Act, but there are exceptions which have the effect of limiting the ability of a property developer to disengage from risk. The effect of the Civil Liability Act 2003 is to constrain and allow for the recovery of damages in negligence claims or claims for compensation for failure to comply with statutory obligations. The duty of care contemplated within the Act goes beyond a cause of action based purely on contract and allows for an adversely affected party who alleges a breach of duty to exercise reasonable care to bring a claim based on negligence or breach of statutory duty. In your notes, I've referred to Burnie Port Authority against General Jones. It's a 1994 High Court decision, and it considered in that case the categories of non-delegable duty in the context of a claim by an occupier of land undertaking a dangerous activity. So property developers need to be aware of that act. They need to be aware of their duty of care generally. And whilst they have an opportunity to join contractors, ultimately property developers remain at risk for a claim made by a party who suffers serious injury or damage on site. Note also the Australian consumer law, which by section 60 provides a statutory guarantee that is a duty of care. And it means that property developers must take care to ensure that in delegating tasks, they consider their own liability. It means looking at checklists. It means undertaking reasonable audit and inspection. Have a look at Leighton Contractors against Fox, 2009, 240 CLR, where the High Court referred to the relevant principles and addressed the circumstances in which an employer, in this context the property developer, may be liable for negligent contract of even independent contractors where injury is caused on site. At page 21 of the decision, the High Court said, an employer owes a personal, non-delegable duty of care to employees requiring a reasonable care is taken. There is a more stringent obligation than the duty to take reasonable care to avoid foreseeable risk. An employer has a special duty that it owes to employees to ensure that reasonable care is taken. Note also the changes in 2017-2018 in Queensland, where the requirements of the Workplace Health and Safety Act 2011 have been changed, with the introduction of Part 2, which is industrial manslaughter. Look at sections 34A through to 34D that provide that a person conducting a business or undertaking, which in our context is a property developer, remains liable in certain circumstances to both civil and criminal sanction in circumstances where a worker dies carrying out work for the business or the undertaking, or is injured and later dies, and the person's conduct to some degree causes that death and the person is negligent about causing the death. There are very substantial periods of imprisonment for individuals, up to 20 years imprisonment, and very substantial fines. So that obligation relates to the person conducting the business or the undertaking, and it extends to the senior officers. So if you are an executive officer of a corporation undertaking property development, you need to be acutely aware of the definition of a person undertaking a business or undertaking. Have a look at Schedule 5 of the Act and Section 5 of the Act also, and think about your obligations as a property developer. Also consider the contractual chain scenarios, the responsibility of various parties within a construction context, and have a look at the notes where I've reproduced contractual chain scenarios which outline the responsibility of various parties as provided for by the QBCC, the Queensland Building and Construction Commission. All right, that is a very brief and relatively quick overview of the important obligations imposed on a property developer when considering entering into a construction contract, and the potential liability for a property developer once the building construction process has commenced. Thank you very much.